Welcome to the Riverside Superior Court Self-Help Services video series on what is an MSC. It's presented by the Riverside Superior Court Self-Help Assistance Services. My name is Patty Rich. First, let's go through the disclosure. While all of our staff members at the Self-Help Center are legal professionals, none of us are able to provide you with legal representation or advice. If you need individual advice or strategy in your case, it will be necessary for you to retain the services of your own attorney. Please take a moment to read this disclosure. As a general overview of the MSC series of videos, Part 1 is going to talk about the difference between community and separate property. Part 2 will go over the mandatory disclosures that must be done. Part 3 reviews the MSC declaration or trial brief and the spousal support declaration and the proper way to serve these documents on the other party. Part 4 is our trial readiness documents series. It discusses the separate statement of undisputed facts and both the witness and exhibit lists. So what is an MSC? MSC stands for Mandatory Settlement Conference, and it is exactly that. It's mandatory, as it is required by the law. It is set in a department with a judge, and it's going to be an attempt for you to settle your case before you go to trial. This may be your first time that the other party and you have sat down to try to discuss the issues in your case. The MSC does not require any formal evidence or hearing, and it doesn't require that all the issues be resolved. What is a trial? A trial is defined as a formal examination of evidence before a judge in order to allow the judge to decide the issues in your case. Because this is a formal examination, the rules of evidence will apply. This is most important when you have an attorney who represents the other party, because they're going to know the rules of evidence and make sure that they apply in the case. The three most common rules of evidence that we see are the laying of a foundation for your evidence, hearsay and its exceptions, and the authentication of your exhibits. When you go to trial, the judge has the final decision on the issues in your case. And the judge is not familiar with what's important to you or the other party. The judge will listen to the evidence presented and will make a decision based upon the law and what he or she feels is appropriate. Also, the judge has no option when going to trial but to divide the assets and debts of the marriage, also known as community property, equally. The statute that controls this says that the court must divide the assets and debts of the marriage equally unless the parties agree in writing. That is the only exception. So it does not matter if there's evidence of abuse, abandonment, arrest, adultery. It cannot affect how the judge decides to divide the community property, assets, and debts. So let's discuss some of the pros of settlement versus the cons of going to trial. First, by settling your case, you can save yourself both time and money. Your settlement conference can be completed in a day, while the trial can spread out over multiple days, and there's no guarantee that they're going to be consecutive. If the court does not have time to continue the trial to the next day, it may be scheduled for days or weeks later. The settlement conference has no costs associated with it. Trial, however, can be somewhat costly. The most expensive of the court fees will be your court reporter fees, which can be as much as $756 a day. While your settlement conference does not require any formal evidence, your trial will require you to obtain formal evidence. You'll not be able to pull your documents out of your file cabinet to introduce them at time of trial unless the other party agrees. In order to obtain formal evidence, you may wish to do subpoena ducus tecums or subpoena your live witnesses. Not only is this a complicated process, but it can be very costly. As an example, my daughter was involved in a car accident. She has a substantial medical history due to a ligament disorder. She was involved in the car accident and hurt her shoulder. The insurance company wanted her medical records, which is reasonable. But I told them they really should limit it to just the shoulder in question. They insisted. So I gave them a general release of the documents. They received 35 banker's boxes filled with medical records, which took them 3 employees and 3 months to review before sending it to their expert. Now you can imagine at 50 cents a page how much that document review and document retrieval cost the insurance company. The next advantage to a settlement conference over trial is that with a settlement conference, you are in control of the outcome. You're at the helm. If you were to go to trial, you're at the whims of the wind, because it is the judge who is at the helm and in control of your fate. Your settlement conference can resolve all of the issues, or maybe you can only resolve a few, thereby limiting the issues that will go to trial. At trial, the judge will resolve all of the issues that are before him or her. At the settlement conference, the parties can divide the assets and debts of the marriage any way they want. They can split it by name, they can give away the farm, they can get the farm, because that statute allows the parties to distribute the assets and debts any way they want. However, if you were to go to trial, the court does not have that option and will have to make orders that divide the assets and debts of the marriage equally. And it will be up to the judge to make that division after hearing all of the evidence in the case. The parties can determine how much will be paid for support, whether it's child support or spousal support. And for spousal support, the parties will determine how long the support will be paid for. The court, however, must use the child support guideline calculator when calculating child support. If the parties do not agree to that guideline, the court has very limited discretion to make orders that are non-guideline in nature. For spousal support, the statute that controls indicates that for a short-term marriage of under 10 years, spousal support can be for half the life of the marriage. For a marriage of 10 or more years, that is considered a long-term marriage, and the spousal support order could be till death or remarriage. The court is going to follow those guidelines. However, you don't necessarily have to. In my case, my ex-husband wanted spousal support, and he wanted a lot of it. We had a long-term marriage, so I risked going to court and getting an order to pay support until death or remarriage. As such, we did agree on a number that was higher than I wanted to pay, but it cut off the spousal support after 7 years. Now, we've been divorced for over 20 years, and he is not dead, nor is he remarried. So the risk I avoided was having to pay spousal support for 20 or more years. rather than paying a little bit more up front for a guarantee that it would stop. That is how you can control your outcome. So what do you have to do to prepare for your settlement conference? Well, first, you'll need to do your disclosures, which consist of your income and expense declaration, your community and separate property declarations, the declaration of final disclosure, the declaration of service of declaration of final disclosure, your settlement conference declaration, and potentially your spousal support declaration. Now, all of these documents should be done not only before your mandatory settlement conference, but also before trial. Specifically, the property declarations, the settlement conference declaration or trial brief, and spousal support declarations would be completed differently if you're preparing for an MSC versus a trial. This concludes our introductory video on mandatory settlement conferences. Please watch the remaining videos in our series, which consist of explaining the difference between community and separate property, going over the final disclosure documents, which include your income and expense declaration and property declarations, preparing your mandatory settlement conference declaration, your spousal support declaration, and then the process to serve all of your documents. And part 4, going over the trial readiness conference documents, which are documents that are required in addition to the documents we discussed in parts 1 through 3. If you're able to settle your case at your hearing or before your hearing, please contact the Riverside Superior Court Self-Help Center to make an appointment. You can do so by telephone at 951-274-4499 or 760-393-2163, or go to our website at riverside.courts.ca.gov/appointments. We'll be happy to help you prepare your settlement documents, including your judgment, review the documents that you have already prepared, and make sure that things are technically correct. Our services are free of charge, but again, we are unable to provide you with legal advice or strategy in your case. Thank you, and we look forward to helping you in the future.